Hello, everyone, and welcome. I'm excited to kick off this presentation with you today. Today's session is brought to you by Continuous Learning Development. We're here to explore some valuable insights and strategies that can help us grow and succeed. Over the next few minutes, we'll cover key concepts, practical tips, and actionable ideas. So, let's get started and make this a productive and inspiring session for all of us. In Islamic law, the term we use for source is dalil, and its plural is adala. Now, dalil literally means guide. Think of a person leading a caravan through the desert. That person is called a dalil because they guide the way. When we talk about the Quran as a dalil, we mean that it serves as a guide for understanding Allah's commandments, or ahkam. It guides us to the kitab of Allah, which contains the specific rulings related to different acts and behaviors. This idea of dalil is very central because it shows that the Quran isn't just a book. It's a guiding source that leads us to understanding what Allah has legislated. Furthermore, the term dalil in this sense is often considered equivalent to other important concepts like usul al-ahkam, which means the roots or foundations of the rulings, and al-masadar al-sharia li al-ahkam, meaning the legal sources of the rulings. So all these terms emphasize that in Islamic law, the dalil or source is what directs us to the principles and evidence behind the rulings. It's a fundamental concept that connects the divine texts to practical legal understanding. Let's start by looking at the sources we generally agree upon and those that are disputed. The Quran and the Sunnah are universally agreed upon, meaning all scholars accept these as the primary sources without dispute. They form the foundation of Islamic law and practice. Beyond these, some sources are accepted by the majority of schools, such as Ijma and Qiyas. Ijma refers to the consensus of scholars, which plays a crucial role in shaping Islamic jurisprudence. Qiyas, or analogical reasoning, is also widely accepted as a method to derive rulings when clear texts are absent. However, it's important to note that not all schools accept these sources universally. For example, the principle of Ijma was not accepted by al-Nazm from the Mu'tazila, as they held different views on consensus. Similarly, some groups like the Khawarij did not accept Ijma. Qiyas, on the other hand, faced rejection from certain schools, notably the Zahiri school and the Jafari school. These differences highlight that, while these sources are significant, their acceptance can vary depending on theological and methodological perspectives. Overall, these sources can be categorized differently based on whether all jurists accept them or only some. Recognizing these distinctions helps us understand the diversity within Islamic jurisprudence and the ongoing debates about authority and interpretation. Let's talk about the two main categories of sources we rely on in Islamic law: transmitted sources and rational sources. Transmitted sources include the Quran, the Sunnah, and Ijma. These are foundational, and their authority is rooted in divine revelation and consensus. When we refer to these sources, reason plays a minimal role in their validation. Their legitimacy is accepted based on their divine origin. However, even though reason isn't the primary factor for their validity, it still plays a role in the legal reasoning that builds upon them. On the other hand, we have rational sources. These include methods like qiyas or analogy, as well as principles like maslaha, public interest, istihsan, which is juristic preference, and istishab, or presumption of continuity. These sources are linked to human mental processes. They involve reasoning and judgment rather than divine revelation. Although they are not transmitted in the same way as the Quran and Sunnah, their acceptance is still considered legally valid. Importantly, the proofs derived from these rational sources often depend on the transmitted evidences for their persuasiveness and legitimacy. So, in essence, transmitted sources form the core of our legal foundation, grounded in divine authority, while rational sources provide additional tools for reasoning, especially in cases where divine texts may be silent or ambiguous. Both work together, enriching and supporting our understanding of Islamic law within the overall framework. Transmitted sources, when we talk about them becoming sources from three aspects, it really helps us understand how Islamic law is developed. First, They do so by clearly indicating the detailed rules of law, such as those related to prayer, zakat, and inheritance. These rules serve as concrete guidelines that followers can rely on. Second, transmitted sources provide legal justification for using methods of reasoning like analogy and maslaha, which are essential for applying the law flexibly and intelligently in new situations. And third, they offer a basis for extending the law through rational sources, allowing us to adapt and interpret the law in a way that suits evolving circumstances. Overall, these three aspects highlight the robustness and adaptability of Islamic legal sources, ensuring they remain relevant and authoritative throughout history. Let's talk about the difference between definitive sources and probable sources. A definitive source, or CADI, is used when we are certain that there can be no two opinions about the matter. It's the strongest kind of evidence we have, leaving no room for doubt. On the other hand, a probable source, or ZANI, is used when the evidence doesn't quite reach that same level of certainty. It's strong, but not absolute. From another perspective, the key point here is that whether a source is considered definitive or probable depends largely on the strength of its transmission. Specifically, it refers to how the source has been transmitted through the first 3 generations of scholars. If the transmission is strong and reliable, it's more likely to be classified as definitive. Understanding this distinction helps us evaluate the reliability of different sources, which is crucial for our overall approach to authentic knowledge. This classification guides us in determining how much weight to give to various reports or narrations we encounter in our studies. Today, I want to talk about the classification of sources according to modern scholars, focusing on 2 key concepts. First, let's discuss what makes a source Kadi al-Sanad. This term means that the report has been transmitted by a large group of people from a large group of people. The idea is that when we have such a wide chain of transmission, it's generally not suspicious because these people couldn't have conspired together to create a falsehood. This kind of transmission is called tawatur, and it's considered very strong and reliable because of the sheer number of transmitters involved. Moving to the second point, a source is also considered definitive with respect to its understood meaning, when the text of the transmitted evidence indicates something that leaves no room for doubt or multiple opinions. In other words, if the message clearly points to a single, unambiguous interpretation, then we can be confident that there is only one correct understanding of that evidence. These classifications are important because they help us determine the level of certainty and reliability we can assign to different sources, which is essential for understanding and applying Islamic teachings accurately. So, in summary, modern scholars have developed these criteria to assess the authenticity and clarity of transmitted sources, reinforcing the importance of strong chains of narration and clear meanings in our study of hadith and other texts. Now, let's explore how this division into definitive and probable sources creates 4 different combinations when it comes to transmitted sources. First, we have sources that are both definitive with respect to sanad, meaning their chain of transmission is solid, and definitive with respect to meaning, so we can be very confident about the message they convey. Next, there are sources that are definitive regarding sanad, but only probable regarding meaning. In other words, we trust the chain of transmission, but the interpretation or understanding of the message might have some degree of uncertainty. Then, we find sources that are probable with respect to transmission, but definitive in terms of the implied meaning. This suggests that while the chain of transmission might not be completely certain, the message itself is understood with high confidence. Finally, the last combination involves sources that are probable both in their transmission and their meaning. These are the sources where both the chain of transmission and the message itself are somewhat uncertain. Understanding these 4 combinations helps us grasp the nuances in evaluating sources, which is essential for our broader goal of assessing the reliability and authenticity of transmitted information. Now, let's talk about primary and secondary sources. Primary sources are those that are unanimously agreed upon by the 4 Sunni schools, meaning they represent the core, most trusted foundations of Islamic law. These are transmitted sources, such as the Quran and authentic hadith, which have been reliably conveyed through chains of narration. On the other hand, secondary sources are mostly rational sources, which involve reasoning, consensus, or analogy to derive legal rulings. It's important to understand that primary sources are considered definitive. They provide the solid, conclusive basis for Islamic law. Secondary sources, however, are viewed as probable. They help fill in gaps or offer interpretations when primary sources don't provide a clear answer. One key point to remember is that laws discovered through primary sources can often be extended or applied further through rational or secondary sources. This flexibility allows Islamic law to adapt and address new circumstances while remaining rooted in the core texts. So overall, understanding the distinction between these sources helps us appreciate how Islamic law is both grounded in divine revelation and enriched by human reasoning, ensuring its relevance and robustness across different contexts. When we talk about grades of sources, we're referring to the priority that jurists give to different sources when they are searching for ahkam, or legal rulings. Essentially, it's about which sources they consider more authoritative or reliable. The first source they turn to is the Quran, because it's the primary and most sacred text in Islamic law. Next comes the Sunnah, which encompasses the sayings, actions, and approvals of the Prophet Muhammad, and it helps clarify and expand on the Quran. After that, jurists look at Ijma, or the consensus of the legal scholars. This consensus reflects the collective agreement of knowledgeable scholars on a particular issue, giving it significant weight. Lastly, if there's no clear guidance in the Quran, Sunnah, or Ijma, they resort to analogy or qiyas, which involves applying existing principles to new situations. Understanding these grades helps us see the logical flow in Islamic jurisprudence, how sources are prioritized to ensure rulings are both consistent and well-founded. This approach underpins the overall methodology in deriving Islamic law, emphasizing the importance of the Quran and Sunnah as the foundation, with other methods serving as secondary tools when needed. The primary sources of Islamic law are the Quran and the Sunnah, but today we'll focus on the Quran as the main source. The Quran is the holy book revealed to the Prophet Muhammad, peace be upon him. It's written in the Musahif, the physical copy of the Quran, and it was transmitted to us through an authentic continuous narration, known as tawatur. This means that the transmission has been passed down through many reliable chains, ensuring its authenticity and integrity without any doubt. What makes the Quran so central is that it is the speech of Allah himself, revealed to Muhammad, peace be upon him. Both the Arabic words and their meanings are part of this divine revelation. This dual aspect emphasizes that the Quran is not just a translation or interpretation. It's Allah's direct speech in its original language, which is why preserving its words and meanings is so important. The concept of tawatur is crucial here because it guarantees that what we have today is exactly what was revealed centuries ago, with no alterations or distortions. And let's not forget the miraculous nature of the Quran, known as ijaz, which refers to its inimitability, and the unmatched linguistic and literary excellence that continues to inspire and challenge believers and non-believers alike. So, in summary, the Quran is the primary source because it's the divine speech of Allah, transmitted reliably across generations, and it forms the foundation of Islamic law and guidance for Muslims worldwide. The Quran was not revealed all at once to the messenger of Allah, peace be upon him, but rather in stages. These stages were closely connected to the incidents and situations faced by the Muslim community at the time. This gradual approach made it easier for the companions to memorize the Quran, which was crucial for preserving its message. Additionally, revealing the Quran in parts allowed for the law to be implemented gradually, giving people time to adapt and understand. This process also led to the phenomenon of abrogating and abrogated verses, where some earlier verses were replaced or superseded by later ones. It's important to understand that many of the verses were revealed in response to specific incidents, cases, or questions that arose among the companions. These situations provided context and helped those who came later to better grasp the meaning and significance of the verses. We refer to these circumstances as the asbab al-nuzul, or occasions for the revelation, and they are key to understanding the Quran's message in its full depth. This approach shows how the revelation was tailored to the needs of the community and how it guided them step by step. The recording and the revelation of the Quran is a fascinating process. The Messenger of Allah, after each verse was revealed, would memorize it himself. He would then recite these verses to his companions, who would listen carefully and memorize them as well. This was a key way the Quran was preserved through oral transmission. At the same time, there were scribes with the Prophet who played an important role. They would record the revealed verses immediately after the Prophet recited them. These written records were kept securely in the Prophet's house, serving as a vital reference. Some scribes would also record the verses for their own use, ensuring that the revelations were preserved accurately. An important point to highlight is that Jibril, the angel Gabriel, would inform the Prophet about the specific place and position of each verse within its chapter, or surah. This helped in organizing the Quran in a coherent and systematic way, which is crucial to understanding and memorizing it. Overall, this combination of memorization, recitation, and written recording was fundamental in preserving the Quran in its original form, ensuring that it remained unchanged over time. During each Ramadan, Jibril would recite the Quran to the Prophet in its proper arrangement, ensuring that the revelation was preserved accurately. It's important to note that in the last year of the Prophet's life, Jibril recited the entire Quran twice, with the Prophet also reciting it twice after him. This highlights the meticulous effort to preserve the Quran in its complete form. By the time of Abu Bakr, the Quran was already in its complete form, either memorized by many companions or recorded in written form on suhuf, which are sheets or pages. This shows how the Quran was carefully preserved both through memorization and documentation from very early on. When Zayd ibn Thabit was tasked with preparing the official copy of the Quran, he didn't rely solely on the memories of the companions. Instead, he consulted both their memorization and the written suhuf. This dual approach ensured the accuracy and authenticity of the final compiled version, safeguarding the integrity of the Quran for generations to come. Let's explore the concept of legal strength and the indication of ahkam in the Quran. Some words in the Quran carry a clear and definite meaning, leaving no room for doubt. Others, however, carry probable meanings, meaning they can be interpreted in two different ways. This distinction is important because it affects how we understand and apply the rulings derived from these words. The Quran indicates the ahkam, meaning the legal rulings, at two levels of strength. First, there are indications that are definitive both in terms of sanad, or transmission, and in terms of meaning. These are the most certain and reliable rulings we find. Second, there are indications that are definitive in sanad but probable in meaning. In other words, the transmission is sound, but the interpretation of the words may vary, making these texts subject to different scholarly interpretations. This distinction highlights the importance of understanding the context and the possible meanings when deriving legal rulings from the Quran. By recognizing these two grades, we can better appreciate the depth and complexity of the Quran's guidance on legal matters, and we see how careful analysis is necessary to ensure correct application. Now, let's look at the different kinds of ahkam in the Quran. First, we have ahkam pertaining to aqaid, which are the tenets of faith. These are fundamental principles that define our belief system and shape our spiritual foundation. They guide us in understanding our relationship with Allah and the core aspects of our faith. Next, there are ahkam related to the discipline and strengthening of the self. These rules help us develop self-control, patience, and resilience. They serve as a means to purify our hearts and strengthen our character, ultimately bringing us closer to Allah. The third category involves rules of conduct, which pertain to our words and actions. This is a broad area that encompasses the entire field of fiqh. Within this, we find two main types: rules related to worship and those related to conduct outside of worship. Rules related to worship include the specific acts of worship prescribed by Islam, such as prayer, fasting, and pilgrimage. These are essential for fulfilling our religious obligations and establishing a connection with Allah. On the other hand, there are rules concerning conduct other than worship. These cover everyday interactions, social manners, and how we behave in our personal and community life. They help us maintain harmony and justice in society. Both of these types of conduct are vital because they shape our moral character and impact our relationships with others. Understanding and applying these rules ensures that our actions are aligned with Islamic principles. And lastly, it's important to remember that all these ahkam are interconnected. They collectively guide us in living a balanced, righteous life according to the teachings of the Quran. The primary sources of Islamic law are the Quran and the Sunnah. When we talk about the Sunnah, we're referring to the teachings and practices of the Prophet Muhammad, peace be upon him. The word Sunnah literally means well-known path or well-trodden path, which is quite fitting because it represents the example set by the Prophet that Muslims are encouraged to follow repeatedly. It's like a guiding trail that has been walked before and provides a clear way forward. Understanding the Sunnah as a primary source is crucial because it complements the Quran and helps us interpret and implement Islamic laws in daily life. Throughout this presentation, we see how these sources work together to shape Islamic jurisprudence and serve as a foundation for Muslim practice. Let's delve into the technical meanings of Sunnah. Some jurists define it as the recommended acts of worship that Muslims are encouraged to do, while others specifically refer to supererogatory acts, also known as nawafil, which are voluntary and beyond the obligatory. It's important to understand that the term Sunnah also acts as an anatomy of bid'ah, or innovation, highlighting what is genuine in religion versus what is an innovation. Additionally, the term Sunnah is often used to refer to the practice of the companions, illustrating how they followed the Prophet's way and set a standard for us. Ultimately, Sunnah is defined as what was transmitted from the Messenger of Allah, his words, his actions, and even his tacit approvals. This comprehensive understanding helps us distinguish authentic traditions from other practices and emphasizes the importance of following the Prophet's authentic way. Let's now explore the different kinds of Sunnah, particularly focusing on the channels through which the ahkam, or rulings, were established. There are three main types of Sunnah based on this aspect: al-Sunnah al-Qawliya, which refers to the spoken words or sayings of the Prophet, al-Sunnah al-Fi'liya, encompassing his actions and practices, and al-Sunnah al-Takririya, which includes his approvals or silent acceptances of certain actions. Understanding these categories helps us grasp how the Sunnah functions as a source of Islamic law and guidance. Each type offers a different perspective on the Prophet's life and teachings, enriching our comprehension of how the Sunnah supports the Quran. Now, shifting to the transmission channels, there are two primary types to consider. The first is muttasil, which means continuous or connected transmission. These are authentic chains of narration that link directly back to the Prophet, ensuring the integrity and reliability of the hadith. Within this category, we have hadith al-mutawatir, which are reports transmitted by so many people across different chains that it's impossible for them to all agree on fabricating it. This type of hadith provides a very high level of certainty. On the other hand, we have hadith al-ahad, which are solitary reports narrated by fewer people. While still valuable, they require careful verification and are often used in supporting roles rather than establishing primary rulings. The second transmission channel is munqati, which refers to broken or disconnected chains of narration. These are less reliable and require more scrutiny before being accepted. By understanding these different types of Sunnah and their channels, we deepen our appreciation of how the teachings of the Prophet are preserved and validated. This knowledge is fundamental to our overall study of Islamic jurisprudence and the way we implement the Sunnah in our lives. Let's discuss the status of the Sunnah in relation to the Quran. The jurists agree that the Sunnah is the second most important source of Islamic law after the Quran. When a mujtahid, or a legal scholar, encounters a case that isn't directly addressed in the Quran, they turn to the Sunnah to help derive the hukam, or ruling. it's essential to understand that if the Quran's text is explicit, or nas, in its meaning, then we are required to act upon it directly. However, if the text is more apparent, or zahir, and can be understood in multiple ways, then we need to look at its commentary. That is, the sunnah, to clarify the correct interpretation. This highlights how the sunnah complements the Quran, ensuring that our understanding and application of Islamic law are both accurate and comprehensive. It's a vital part of our overall framework for understanding and practicing our faith. When we look at how the sunnah establishes the ahkam, or rulings, we see that it functions as a commentary on the Quran. It helps clarify and explain the divine guidance found in the Holy Book. The sunnah also connects cases that might seem uncertain or wavering with established principles, providing a clear link between specific situations and general rules. Additionally, the sunnah performs analogy, or qiyas, based on rules already mentioned in the Quran. This means it helps us extend principles to new circumstances while staying within the framework of the original divine guidance. It also lays down broad, general principles that guide how we interpret and implement the Islamic law. Furthermore, the sunnah elaborates on the meanings of words in the Quran, giving us deeper insight into what Allah intended. And very importantly, in some cases, the sunnah abrogates the Quran, meaning it supersedes or clarifies earlier rulings when divine guidance evolves or clarifies itself over time. All of these functions show how integral the sunnah is in understanding and applying Islamic law, connecting the divine text with practical, everyday life. When we look at modern perspectives on the relationship between the Quran and the sunnah, we see that there are generally three main viewpoints. The first group emphasizes the Quran itself, giving it greater prominence and highlighting its coherence as the primary source of guidance. They believe that the Quran is complete and self-explanatory, and therefore, it should be the main focus in understanding Islamic teachings. On the other end of the spectrum, there are those who stress the importance of the sunnah, but with a specific criterion. Their acceptance should be based on the chain of transmission, or isnad. They argue that the authenticity of the sunnah depends on the reliability of its transmitters, ensuring that what we accept is genuinely from the Prophet Muhammad, peace be upon him. Then, in the middle, we find a group that considers both the isnad and the matn, the actual text, important. They believe that a balanced approach, which evaluates the chain of transmission and the content of the narration, is essential for understanding and applying the sunnah correctly. This middle approach aims to safeguard the integrity of the tradition, while also appreciating the context and meaning of the sayings. Overall, these perspectives reflect different ways scholars and Muslims approach the relationship between the Quran and the Sunnah, emphasizing coherence, authenticity, and balanced evaluation. Today, we're going to explore the concept of aima. The word itself actually has two main meanings. The first is about determination and resolution. Think of it as a firm decision or a strong resolve. The second meaning relates to agreement upon a matter, when people come together and reach a consensus. Now, when we talk about aima, in a technical or legal sense, it specifically refers to the collective agreement of mujtahids, independent scholars or jurists, who are part of the Muslim community after Prophet Muhammad's, peace be on him, time. These scholars, over a certain period, come to a consensus on a particular rule of Islamic law, known as Hulm Shari. This consensus is very significant because it reflects the unified understanding and interpretation of Islamic legal principles by those qualified to do so. It helps ensure that Islamic law remains consistent and authoritative even as time passes. So, in essence, aima is about the collective, scholarly agreement that shapes and sustains the application of Islamic law after the Prophet's era. Let's delve into the conditions necessary for the validity of aima. First, it's important that the agreement or consensus is reached among the mujtahids. These are the learned scholars qualified to interpret Islamic law. Their collective agreement lends legitimacy to the consensus. Next, the consensus must be unanimous among all the mujtahids involved. This unanimity ensures that there are no dissenting opinions, which is crucial for the validity of aima. Additionally, all the jurists participating in the consensus should be from the Ummah of Muhammad, peace be on him. This emphasizes the importance of unity within the Muslim community and ensures the consensus reflects the collective understanding of the faithful. It's also essential that this agreement occurs after the death of the Prophet, peace be on him. Since the Prophet's lifetime was the period of revelation, the consensus is meant to interpret and apply Islamic law in its absence. Finally, the consensus should be among mujtahids from a specific period, even if some later scholars disagree. This means that the agreement is rooted in a particular historical context, which helps maintain its relevance and authenticity. All these conditions together help us understand how AIMA functions as a reliable source of Islamic jurisprudence, reinforcing the unity and consistency of Islamic law over time. Let's discuss the conditions for the validity of AIMA. First, the agreement must be based on a rule of law, specifically the Shari law. This means that the consensus should align with established legal principles. Second, it's important that the mujtahids, or Islamic jurists, relied on a sanad, or a reliable chain of narration, when deriving their opinions. This ensures the authenticity and credibility of their consensus. Third, interestingly, according to the majority, the death of those jurists who participated in the AIMA, whether their death was explicit or implied through silence, is not a condition for the validity of the consensus. This means the consensus remains valid even if some jurists have passed away. Lastly, for the AIMA to be considered valid, it should have been transmitted to later jurists through tawatur, which is a widespread, continuous transmission that guarantees authenticity. These conditions help us understand how carefully the concept of AIMA is maintained within Islamic law, ensuring its legitimacy and authority. Today, I'll be explaining the two main types of AIMA. First, we have the explicit AIMA, or AIMA Qali. This occurs when all the jurists of a particular period agree on a legal issue, and each one clearly states their opinion. It's like a consensus where everyone's voice is openly expressed, leaving no doubt about the common ruling. Then we have tacit AIMA, or AIMA Sukuti. This form happens when some mujtahids, one or more, issue a verdict on a legal matter, and others become aware of this during the same period. However, instead of openly agreeing or disagreeing, they remain silent. They neither acknowledge the opinion nor explicitly refute it. Both types are crucial because they show different ways jurists reach consensus, either through explicit agreement or silent acceptance, which plays a significant role in shaping Islamic legal thought and practice. This understanding helps us see how collective opinions develop beyond just spoken consensus, contributing to the overall fabric of Islamic jurisprudence. Now, let's discuss the conditions of tacit AIMA. First, it's important to understand that the silence involved here must be completely free of any external signals or indications that might suggest agreement or disagreement. In other words, there should be no body language, gestures, or verbal cues that could be interpreted as a stance on the matter. This ensures that the silence genuinely reflects a lack of objection or approval. Next, the silence of a mujtahid, or a qualified scholar, should be maintained over a long period of time. This isn't a quick or momentary pause. It's a sustained, deliberate silence that indicates thoughtful abstention or acceptance. This prolonged silence adds weight to the tacit consensus and helps distinguish it from mere neglect or oversight. Third, the issue at hand must be one where ijtihad, or independent reasoning, is permitted. Not every matter qualifies for this kind of tacit consensus. It needs to be a topic where scholars are allowed to exercise their judgment and interpret religious laws without explicit directives. Understanding these conditions is crucial because they help us recognize when a silent agreement truly signifies a collective understanding or consensus among scholars, which plays a significant role in Islamic jurisprudence. Let's talk about the legal force of AIMA as a source of Islamic law. First, focusing on the binding strength of explicit AIMA. The majority of jurists agree that when there's explicit consensus, meaning everyone clearly agrees, that it's a definite source. And importantly, they emphasize that acting upon this explicit AIMA is obligatory. In other words, once there's clear consensus, it's not just a suggestion, it's a legal requirement. Opposing this explicit agreement is considered prohibited because it would go against the collective understanding and authority of the scholars. Now, moving on to tacit AMA, or implicit consensus. This is where it gets a bit more complex. Some jurists hold that the binding strength of explicit AMA remains firm, but they are more cautious about tacit AMA. In fact, some even refuse to recognize tacit agreement as a valid source of law at all, or they might deny calling it AMA because it lacks the clarity of explicit consensus. This difference highlights how crucial clarity and explicit agreement are in establishing authoritative legal rulings in Islamic law. Throughout this discussion, we see how the strength and recognition of AMA shape the development and stability of legal principles, which ties into the broader theme of understanding authoritative sources in our presentation. Most jurists agree that every AMA needs a sanad, or a chain of transmission, that the jurist can rely on when forming an opinion. Without this sanad, the AMA would essentially be based on Rai, which is personal opinion, and that is rejected by the Sharia. The majority also believe that AMA is not just a theoretical concept. It has actually taken place throughout Islamic history. It's a recognized source of law that all Sunni schools accept, just like they accept the Quran and Sunnah. However, what's interesting is that, despite this broad acceptance, there's no formal established system for its transmission. This means that while AMA is highly valued and accepted, its documentation and verification can sometimes be less structured compared to other sources. Today, I want to talk about the concepts of maslaha and manfa, which are essentially synonymous and mean benefit and utility. When we look at their literal meaning, maslaha is defined as jalb al-manfa wadaf al-madara, which translates to the seeking of benefit and the repelling of harm. In a more technical sense, it refers to the idea of seeking benefit and avoiding harm, but importantly, this is always in accordance with what the lawgiver, Allah, guides us to do. It's not just about what seems beneficial on a human level. It's about aligning with divine guidance to ensure that our actions promote benefit and prevent harm. Another key point is that the pursuit of utility in Islamic law isn't dependent on human reason or personal pleasure. Instead, it follows a higher, divine framework that prioritizes what is truly beneficial according to Sharia, not just what might feel good or seem logical to us. Finally, it's important to see how maslaha connects with the broader maqasid al-sharia, or the higher objectives of Islamic law, which aim to preserve religion, life, intellect, lineage, and property. These are the overarching principles guiding the pursuit of benefit and the prevention of harm in our faith. Let's explore the classification of maslaha, or public interest, in relation to the Sharia. As we know, some maslaha are acknowledged or rejected by the Sharia itself. Today, we'll focus on 4 types of maslaha that are discussed under this heading. Starting with the lowest category, we see that maslaha can be acknowledged at this basic level. For example, take the case of drinking khamr, or wine. The underlying cause or reason at this level is often something like intoxication. Recognizing this as a harmful effect, the rational source we invoke here is analogy, or qiyas. What does that mean? Well, by using analogy, we extend the ruling from what we know about khamr to similar substances. So, we consider that anything that causes intoxication, regardless of its specific form, should be prohibited. This way, the prohibition isn't just about wine itself, but about any substance that intoxicates. This approach shows how the Sharia uses rational reasoning to guide us in extending rulings, ensuring that the general principle of avoiding intoxication is upheld. And this helps us see how maslaha, even at its simplest level, plays a crucial role in shaping Islamic law. Let's now look at how maslaha is acknowledged within Islamic law. It is recognized at the level of genus, which means it's considered at a higher level than the lowest categories. Essentially, this means that the recognition of certain benefits or interests isn't just at a superficial level, but at a more comprehensive, broader level that considers the overall purpose of the law. This recognition of attributes can extend all the way up to the highest level of the purpose of law itself. In Islamic jurisprudence, the ultimate goals or maqasid of Sharia are fivefold. These are the preservation of din, which is the faith, the preservation of life, the preservation of nasl, meaning progeny or lineage, the preservation of intellect, and the preservation of wealth. These 5 objectives serve as the foundation for evaluating what is considered beneficial or harmful. Now, not all maslaha is accepted. There are cases where maslaha is rejected by the Sharia. Specifically, this happens when a maslaha clashes directly with the clear texts of the Quran and Sunnah. In such situations, the divine text takes precedence over the benefit or interest that might otherwise be considered. Finally, there are maslaha that fall into a gray area. They are neither explicitly acknowledged nor rejected. These are the interests that are not clearly supported or opposed by the texts, which often require further analysis or reasoning to determine their permissibility or importance within the framework of Islamic law. By understanding these distinctions, we see how Islamic law carefully balances benefits against divine commandments, ensuring that the ultimate objectives of the law are upheld. Let's explore the classification of maslaha based on its inner strength. This approach looks at the purpose of Islamic law and how it aims to serve various vital interests. There are 3 main types under this classification. First, we have darurat, which refers to necessary interests. These are the essential needs that must be protected for a balanced and just life. Within darurat, there are 5 key areas we focus on. The first is hifz, ala al-din, or the preservation and protection of religion. This is fundamental because faith shapes our identity and moral compass. Next, we have hifz, ala al-nafs, which means safeguarding life itself. Preserving human life is a core principle in Islamic law. Then, there's hifz, ala al-nasl, or the protection of progeny, emphasizing the importance of family and lineage. Another critical aspect is hifz, ala al-aql, the preservation of intellect, recognizing that knowledge and wisdom are vital for individual and societal growth. Lastly, we consider hifz, ala al-mal, which is the protection of personal wealth. Wealth security enables individuals to live with dignity and fulfill their needs. Moving on, the second category is hajat, which refers to supporting needs. These are not as urgent as darurat, but still important for a comfortable and stable life. The third category is tahsinat, or complementary interests. These are additional benefits that enhance our lives, but are not necessarily essential. Understanding these classifications helps us see how Islamic law prioritizes different types of interests to maintain balance and justice in society. Today, I want to talk about the classification of maslaha, which is a key concept in understanding how interests are categorized in Islamic jurisprudence. First, let's look at the idea of definite and probable interests. Some jurists believe that certain interests are considered definite, or qat'i, meaning they are clear and certain. Others are seen as probable, or zanni, which means they are likely but not absolutely confirmed. The interesting part here is that these classifications are often based on a process of induction, or istiqra, rather than deduction. So, rather than deriving these interests from strict principles alone, they are inferred from observed evidence and experiences. Next, we move to the distinction between public and private interests. When we talk about necessary needs, supporting needs, and complementary interests, these can be divided into those that serve the public and those that serve private individuals. This division is important because, in legal disputes, conflicts frequently arise, either between public and private interests or between 2 private interests. Resolving these disputes often requires balancing these different types of interests to achieve justice and fairness. So, in the broader context of our discussion on maslaha, understanding these classifications helps us see how interests are prioritized and managed within Islamic law, ensuring that the overall welfare is protected while also respecting individual rights. Let's talk about qiyas, which literally means measuring or estimating one thing in terms of another. In a technical sense, as defined by the jurists, qiyas involves assigning the hukam, or ruling, of an existing case, one that we find in the Quran, the Sunnah, or Amma, to a new case. and we do this based on a shared underlying attribute, which is called Ilah of the Hukam. So, essentially, Qiyas helps us extend existing rulings to new situations by identifying a common cause or reason behind them. This method is important because it allows us to apply Islamic law consistently when direct texts don't address a particular issue. It's a key part of secondary sources in Islamic jurisprudence, helping us bridge gaps and adapt to new circumstances while staying true to the original sources. Let's take a closer look at the elements of qiyas, or analogy, which is a fundamental method of reasoning in Islamic jurisprudence. First, we identify the case or set of facts that has already been discussed in the text, along with its hukam or ruling. This means we understand what the original ruling is for that particular situation. Next, we examine the ilah, which is the underlying cause or reason that led to that hukam. Recognizing the ilah is crucial because it helps us see the connection between the original case and other cases. Finally, we look at the new case or set of facts where the hukam hasn't been explicitly mentioned. This is where qiyas comes into play, as we use the knowledge of the original case and its ilah to derive the hukam for this new situation. By understanding these elements, the original case, its hukam, the ilah, and the new case, we create a logical bridge that allows us to apply established rulings to new scenarios, maintaining consistency and fairness in our legal reasoning. Let's discuss the key points regarding the condition pertaining to the hukam of the asl or the case in the texts. When we talk about a hukam that is directly established from the Quran, Sunnah, or Ijma, it means that the evidence is clear and authentic, giving the hukam a solid foundation. It's important that a determined ilah or cause is identified for this hukam. This means we need to understand the specific reason or condition that justifies the ruling in the text. Knowing the ilah helps us apply the hukam correctly and consistently. Additionally, the hukam should not have been abrogated. Abrogation occurs when a later text overrides a previous one, so we must ensure that the ruling remains valid and applicable. Another crucial point is that the hukam should not be restricted to a specific case by another text. If a text limits a ruling to a particular situation, then it's not a general hukam that applies broadly, which is often the case we're discussing here. We also need to confirm that the hukam does not pertain to exemptions. Exemptions are special cases where the general rule doesn't apply, so we're focusing on rulings that hold universally unless specified otherwise. Finally, the hukam should not relate to criminal law. Criminal laws often have different considerations and criteria, so for the purposes of this discussion, we're focusing on rulings outside the criminal justice context. By understanding these conditions, we ensure that the hukam we derive is sound, universally applicable, and rooted in authentic sources. Today, I want to talk about the conditions that pertain to the far or the new case needing a hukam. Remember, we're focusing on the principles that guide us when we encounter something new in Islamic law. First, it's important to understand that the ilah of the asl, or the original case, must be present in the far. In other words, the underlying cause or reason that applied to the original case should also be found in the new case. Now let's look at the specific conditions for the validity of the ilah. The first point is that the ilah must be an apparent one. This means it should be clear and observable, not hidden or ambiguous, so we can confidently identify it in the new case. Next, the ilah should be a constant and stable attribute. It must be something that remains consistent over time and doesn't change, ensuring that the hukam remains applicable. Additionally, the ilah should be extended and not confined to the asl. In other words, it should have a broad application, applicable in various situations, not just the original one. Finally, the attribute that constitutes the ilah should be compatible with the purposes of the law or manazib. This means it should align with the broader objectives of Islamic law, like justice, mercy, and wisdom. By understanding these conditions, we ensure that our application of law to new cases remains sound, consistent, and aligned with the overarching principles of Islamic jurisprudence. Let's talk about the types of qiyas, or analogy, and how they are classified into probable and definite, or kadi and zani. When we say qiyas is considered definite, or kadi, it means that two key conditions are met. First, the mujtahid, the expert making the analogy, must be fully convinced about the ilah, or the reason he has identified in the asl, which is the original case. This conviction is essential because it shows that the reasoning is solid and well-founded. Second, the ilah found in the far, or the comparable case, must be exactly the same, meaning there are no distinctive or differentiating attributes that set it apart. If both these conditions are satisfied, then the analogy is considered definite, giving it a higher level of certainty. Connecting this to our overall theme, understanding when qiyas is definite helps us gauge the strength of the reasoning behind legal rulings. It highlights the importance of clarity and certainty in deriving Islamic law through analogy. Now, let's explore the classification based on the strength of the hukam established in the far. First, we have qiyas Allah, which refers to situations where the hukam established through analogy is of a higher order. This means that the ruling derived from this analogy carries a more authoritative or stronger position compared to others. Next, we have the case where the hukam established is of the same strength. This is known as qiyas that is of the same level, indicating that the analogy and the original ruling are equally authoritative and neither takes precedence over the other. Moving on, we have qiyas idwan, which refers to a lower order of analogy. In this case, the ruling derived from the analogy is considered less strong or less authoritative compared to the primary hukam. Now let's touch on the types of qiyas, specifically qiyas jali and qiyas khafi. Qiyas jali, or manifest analogy, is quite clear and evident. You can easily see the similarities that justify the analogy, making it straightforward to derive rulings. On the other hand, qiyas khafi, or concealed analogy, is more subtle and less obvious. The similarities are not immediately apparent, requiring deeper analysis and careful consideration to establish the analogy. Understanding these classifications helps us see how different analogies are prioritized and applied within Islamic jurisprudence, ensuring that rulings are both consistent and well-founded. Istihsan, or juristic preference, literally means to consider something good. In a technical sense, it refers to giving preference to a stronger evidence over analogy when making legal rulings. There are different types of istihsan that scholars recognize. One is istihsan through the text, or nas, where clear textual evidence guides the preference. Another is istihsan based on ema, which is consensus among scholars on a particular issue. We also have istihsan based on what is good, known as maraf, which involves considering societal benefits and moral good. Then there's istihsan on the basis of necessity, or darura, where urgent needs justify a preference for a certain ruling. Additionally, scholars consider istihsan based on maslaha, or public interest, emphasizing the welfare of the community. Lastly, there's istihsan on the basis of qiyas khafi, or a subtle analogy, where a nuanced comparison leads to a preferred ruling. All of these types show how jurists use various methods to arrive at rulings that best serve justice, benefit, and public interest, connecting to our overall theme of understanding flexible, yet principled legal reasoning in Islam. Today, I want to talk about istishab, which is often called the presumption of continuity. The word itself, istishab, means the continuation of companionship or ongoing presence. In technical terms, it refers to the presumption that an earlier rule or its continued absence remains in effect until there's evidence to the contrary. The core idea here is that we start from the principle that the original rule for all things is permissibility. That means, unless there's a reason to think otherwise, we assume that things remain as they are. Now, one of the foundational principles behind istishab is bara asliya, which essentially means there's no presumption of liability against anyone. In other words, a person is not assumed to be liable unless it's proved otherwise. And importantly, istishab certainly doesn't give way to doubt. If there's uncertainty or doubt about whether a certain rule has changed, the presumption remains in favor of the continuation of the original state. So, in the context of our overall discussion, istishab helps us make decisions by maintaining stability and continuity unless clear evidence indicates a change. It's a vital concept that ensures fairness and consistency in applying Islamic legal principles. Let's talk about the different types of istishab. First, there's the situation where the absence of a dalil or clear evidence is known with certainty. In this case, we are sure that no evidence exists to support or oppose a particular ruling. Next, we have cases where, after thoroughly examining the general evidences, it becomes obvious to the jurists that there is some evidence out there that could actually change the existing hukam, or ruling. This means that even though we haven't yet identified the specific evidence, it's clear that such evidence could alter the current judgment if found. Then, there's a scenario where a hukam is being continued or assumed without any effort to seek out evidence that might actually change that rule. In other words, the ruling is simply maintained without actively searching for evidence that could lead to a different conclusion. Finally, istishab can also be used for establishing a rule ab initio, meaning from the very beginning. This is when we rely on istishab to establish a ruling right from the outset, based on the assumption that the initial state remains unchanged until proven otherwise. Understanding these types helps us see how istishab functions within our legal methodology, especially when evidence is unclear or incomplete. Today, I want to focus on the concept of maslaha mursala, or extended analogy. It's fundamentally about ensuring that benefits are gained and harms are avoided. In simple terms, it's about promoting what is good and preventing what is bad. More specifically, it refers to the preservation of the core purposes of Islamic law when we're solving legal issues. This means that even when there isn't a clear text, we look at the bigger picture, what's best for the community and the overall goal of the Sharia. This concept helps us to adapt and apply Islamic principles in new situations, always aiming to serve the greater good without compromising the integrity of the law. It's an important tool for ensuring that Islamic law remains relevant and effective in diverse contexts. So, in essence, maslaha mursala is about balancing benefits and harms to uphold the true objectives of Islamic law in all legal reasoning. Let's explore the 4 types of maslaha based on how they are accepted or rejected by the Sharia. First, we have maslaha that is acknowledged by the lawgiver at the level of the lowest nawa. This means that even the simplest or most basic benefits are recognized and taken into consideration in Islamic law. Next, we have maslaha acknowledged at the level of the genus, or jins. This refers to benefits that are recognized when we look at broader categories or groups, rather than specific instances. Then there are maslaha that are not acknowledged by the Sharia at all. These are benefits that the law does not recognize or consider relevant, and therefore, they are not used as a basis for legal rulings. Lastly, we have maslaha that are neither acknowledged nor rejected by the Sharia. These are benefits that the law remains neutral about, neither endorsing nor dismissing them. Understanding these distinctions helps us see how Islamic law evaluates different benefits and guides us in applying the principles of fairness and justice in our actions. Sad al-Daria, or the concept of blocking the lawful means to an unlawful end, is a key principle in our discussion today. It's about preventing actions that are lawful in themselves but could lead to unlawful outcomes. Essentially, it's concerned with acts that are permissible but might result in harm or sin if they lead to something forbidden. Now, when we look at different types of lawful acts, the first category includes those that rarely lead to harmful results. For these, the benefit of allowing such acts usually outweighs the potential harm, so they're generally permitted. The second category consists of acts that often lead to harmful results. Here, the harm caused by these acts is significantly greater than any benefit gained, so they're usually prohibited to prevent that harm. Finally, there are acts where the chances of benefit and harm are roughly equal. In such cases, the decision to permit or prohibit depends on a careful assessment of the specific circumstances and potential consequences. This principle reminds us how important it is to consider not just the act itself, but also its potential outcomes, especially when the line between lawful and unlawful can become blurred. It ties back to the overall theme of safeguarding moral and legal boundaries in our actions. Now, let's take a look at some other secondary sources that can help us understand Islamic law better. First, we have the companion's opinion, known as Qawl al-Sahabi. This refers to the views and interpretations of the Prophet's companions, which are often considered valuable because they were close to the Prophet and understood his teachings directly. Their opinions can serve as important secondary sources when primary texts are not explicit. Next, we have Shar Man Kablana, or earlier scriptures. These include texts like the Torah and the Bible, which are considered previous divine revelations. They provide context and background, especially when discussing issues that have roots in earlier divine laws or narratives. Finally, we have the concept of custom, or urf. This refers to the customary practices and social norms of a community. In Islamic law, urf can sometimes influence legal rulings, especially when they do not contradict core principles. Recognizing local customs helps in applying Islamic law in a way that is relevant and practical for specific communities. Together, these secondary sources complement the primary texts and help us form a more nuanced understanding of Islamic legal principles, aligning with the overall theme of comprehensively studying sources of Islamic law.